Thank you, Fabiola, and thank you everyone for joining our webinar today. I do want to emphasize again that you can place questions for our presenters in the chat throughout the webinar. We will keep track of those and make sure we cover those at the end. We have a lot of time for some Q&A at the end of our presentation today. But if you have come to learn more about the National Council of Juvenile and Family Court Judges, brand new bench cards for military families who are court involved, you have come to the right place. We're very excited to debut our bench cards with our group today. And this has been a project with a lot of blood, sweat, and tears and a long time coming. And we really appreciate the folks that have joined to listen to our presentation. Now, our project at the National Council of Juvenile and Family Court Judges, first and foremost, is funded by the State Justice Institute. It is under an award that we have had from the State Justice Institute going back to around 2018. And we just have to let you know that the comments and discussion and content today was developed by the NCJFCJ and are the views and opinions of our presenters, but not necessarily of those of the State Justice Institute. But we have a very good relationship with SJI and we fully appreciate their support. My name is Sherry Ely, and I'm the Program Director for Juvenile Justice here at the National Council. And I just want to provide you a little bit of overview about our military families and the courts initiative before we talk about the bench guards and kind of lay out the path or the road on how did we get to the point of needing bench guards. Our work at the National Council really goes back to around 2011. And that is the year that a report came out from the White House on strengthening our military families. And some of the things that were said in that report were that court systems need to be more responsive to the unique needs of veterans and families when they become involved in the justice system. And that report is still available online, but we took that report to heart and our board of directors developed a resolution that same year that really demonstrates the NCJFCJ's commitment to education for judges and those who work in the court system about military families, their unique needs, our commitment to providing what we call technical assistance materials or additional resources to the justice field about military connected families. These bench cards are one of those types of technical assistance materials, and then really promoting collaboration between courts, court systems, communities where military families live, and military installations to better serve those families. As part of this project that we began around 2018, we have developed a couple of products that led to the bench cards. The first was in 2022, we developed a template guide to develop a memorandum of understanding between a military installation and a court, because there are many situations where we need to have agreements between courts and military installations to address things like civil protection orders and access on base for investigating reports of child abuse and neglect. Oversight for probation and parole for adults and youth that may live in a military installation. So there's a variety of reasons that we might need those types of agreements, and we've developed a template guide on putting those agreements together. In 2023, we developed our judicial resource guide on military families in the courts, covering cases that involve families with child abuse and neglect, juvenile justice issues, family violence and emergency relief, and domestic relations or divorce, child custody, child support issues. That QR code will take you to our National Resource Center for military connected families in the courts. That's part of the NCJFCJ website. That QR code and that link will take you directly to the Resource Center, which is where you can find not only the new bench cards that we're debuting, but also that template guide to the developing an MOU and then the judicial resource guide, as well as other resources, which include things like our webinars. As you noticed at the beginning, we are recording this webinar, and within a few days, it will be placed in the Resource Center for viewing after the webinar has ended. And please feel free to share these with folks that you think may be interested in the resources. This is what leads us to our military families in the courts bench card being developed. Once we develop the resource guide, and it's a little bit a thicker publication. It's not something that you can read while a judge is on the bench or during a hearing. We really felt that sometimes there are cases that judges do not know is a military connected family. And so in the moment in a hearing when that might be discovered, we really thought it would be really useful to have bench cards that a judge is able to pull out during a hearing to just sort of remind them of some of the considerations, some of the questions that they should be asking, some of the things they might want to include in a court order, and then what are some additional resources in this topic area that they might need after the hearing. Our group took about a 15-month process to develop these bench cards. They were drafted by work groups that consisted of members of our military committee and members of our NCJFCJ staff team. These bench cards, once they were developed, were reviewed many times by our military committee for edits and feedback. And then we also took them to the NCJFCJ advisory committees for child welfare and juvenile law, for family violence and domestic relations. And our research division, the National Center for Juvenile Justice, has a board of fellows. And all of these advisory groups were able to review and provide feedback so that we made adjustments to these bench cards before they were published. We published them as one packet or one package for ease of use. There are 3 complete bench cards in the package. One is addressing child welfare cases. One is addressing family violence and emergency relief. And the 3rd bench card is addressing juvenile justice issues. Each bench card comes with, the package comes with resource links and a terminology page. If you've ever worked with the military and installations, there's quite a bit of terminology that's new to those that are civilians or non-military members, and a lot of acronyms. And so it's not an exhaustive terminology page, but anywhere we've used the military terminology or acronyms in our bench cards, those are in the resource list at the end of the package. I want to introduce you today to our presenters. We have 3 judges who are going to present to you about each bench card and field some questions. That picture right there, though, that is the front cover of our bench card package, and that QR code will take you directly to the bench card. So feel free to scan that so you can have the bench cards open while we're doing the webinar. And our presenters were all members of our military committee and members of the work groups that developed each of the bench cards. We're very excited to have Judge Gail Branham Carr. She is a retired juvenile and family court judge from Fairfax, Virginia, longtime member of the military committee, and a past president of the National Council. Judge Carr, would you like to say a few words, please?
Thank you, Sherry. Good morning, good afternoon to all of you. Thank you for joining us on this very important webinar on our newest bench card. As Sherry mentioned, I am a retired judge, retired last August after 30 years in the Juvenile and Domestic Relations District Court. My court handles juvenile delinquency, child welfare, family law, chins, delinquency, everything we do in terms of family and juvenile except divorces. That's the only thing we don't do. We do misdemeanors, felonies involving both juveniles and adults. Sherry mentioned I'm a past president of the National Council of Juvenile Family Court Judges. And right now, even though I retired last August, I still hear cases on a part-time basis. So I'm still very much involved in this area of law. And I became really interested in military and families and courts because I'm in Virginia, right outside of Washington, D.C. We have several military bases here. The closest to me is Fort Belvoir. And so I had a lot of involvement with coming to a memorandum of understanding, which you'll be hearing about later. So thank you for joining us.
Thank you, Judge Carr. Our next presenter is Judge Jason Fleming. He is from Christian County, which is Hopkinsville, Kentucky. He is a longtime member and past chair for the military committee and a member of the advisory committee for our family violence department. Judge Fleming, would you like to say hello?
Good morning and afternoon. Jason Fleming. I'm family court judge in Christian County, Kentucky. if you think of Kentucky, you normally think of Louisville and Lexington. Well, I'm down in the western part. I'm down in that little thin part. I'm actually just an hour north of Nashville, Tennessee. So whenever we do something, we drive to Nashville. I'm 2.5 hours from Louisville and about 3 hours from Lexington. But I have a kind of a unique situation. Fort Campbell, Kentucky is in my county, but Fort Campbell, half of it is in Kentucky and half of it is in Tennessee. The only reason they call it Fort Campbell, Kentucky is the post office is located on the Kentucky side of base. So it makes a whole lot of interesting jurisdictional issues when you have a base that is divided like ours is, with half in one state and half in another, because federal installations are not in any state. They are their own country, basically. They're their own state in a way. But we've drawn an imaginary line through Fort Campbell of where the border would be. And anything that is north of that line is me in Kentucky, and anything south of that line is in Tennessee. So what you have is you have people that will leave Fort Campbell, and one will go to Tennessee to get a protective order, and one will come to Kentucky to get a protective order. And then me and the judge in Tennessee will have to sort that out. And we've got each other on speed dial, I will guarantee you. But it's an honor to be a part of this. And I'm in my 19th year of service on the bench.
Great. Thank you, Judge Fleming. And we also have Judge John Romero. He is a retired judge from Albuquerque, New Mexico. He is the current chair of our military committee, and he's also a past president of the National Council. Judge Romero, would you like to say hello, please?
Thank you, and happy Wednesday, everyone. As Sherry indicated, I am a retired judge, about to complete my 5th year of retirement, but I'm not sure what retirement means, because we stay busy when we love and have a passion for this work. And some of it I get to do locally with our New Mexico folks, and most of it I get to do with the National Council, still involved in teaching and training judges and other court professionals nationally. In case you're wondering, the picture behind me is Minneapolis, Minnesota. We don't have that kind of water in New Mexico, but you know, I can only dream. I spent 4 years in the military, the U.S. Navy, back in the early 70s. Spent the first year all along the East Coast from Orlando, Florida to Norfolk, Virginia. Not necessarily near Judge Carr's stomping grounds, but still a very concentrated area of military activity, specifically Navy, and then spent some time in Newport, Rhode Island. From there, I went to San Diego, California. That basically comprised my first year and a half in the Navy, most of it getting trained. And then I spent the remainder of my time through about mid-1974 in the Republic of the Philippines as a naval communication officer. Great experience, but you know, I got to witness and be part of some of the issues we talk about now, the relocations that occur frequently, separation from family, and very importantly, the Navy is, at least back when I was in it, they didn't care then about your family and what your personal issues were. Are you mission ready? Are you ready to do what the Navy requires of you, which could mean moving in an instant. But the Navy is a much friendlier place now, from what I understand. Still those cultural differences, the jurisdictional issues, and the unique pressures faced by military families and military active duty members face as well. And we're talking not just about active duty military, but also National Guard, the reserves, all of whom are touched, along with their families, in the issues we will present today. I do want to take a moment to thank Sherry for her guidance and direction in the military committee, and very importantly for all of the staff who helped. Without them, we couldn't get any of this done. So a shout out to all of our staff support and the work that they do in making all of this possible, and continue to work not just on this project, but many other projects. Thank you.
Thank you, Judge Romero. And again, the members of the military committee who participated in the bench cards include these 3 judges that are presenting with you today. They're all current members of the military committee. And so I'm so glad that they were able to share with you some of their experience and their connections to the military, either through their job as a judge or where they live or through past service. And we appreciate that. And again, that is the QR code to the bench cards. And I'm going to change the screen. So you've got about one more second to scan that to go to the bench cards. We just had a couple new folks join us to make sure that's available. The first bench card that we're going to talk about is the child welfare bench card, and I'm going to turn that over to Judge Romero to give you an overview of the child welfare bench card.
Thank you, Sherry. And as you can see from the screen, this is not necessarily a standard bench card, but much of the flow that's outlined in this first page of a two-page bench card is critical. Whether you do a lot of military connected families, and very importantly, if you only do one every now and then, these are important questions to ask. And if you have a neglect and abuse case or a dependency case, it's called in some parts of the country, or CHIPS case in Minnesota, one of the first things you want to ask, and hopefully your child welfare agency and their investigative part has already asked some of these questions, but you want to make sure you can't leave anything to chance. So is either of the parties in this case an active duty service member? And then some other questions to ask, are both of them, is one of them, and very importantly, is the service member required to carry a weapon as part of their duty? If so, that lends itself to a whole host of other questions. So I think Judge Fleming may touch on that in terms of how it impacts domestic violence cases. And then, is the service member deployed? I mean, it wouldn't be unusual that a child or a family is being investigated for neglect and abuse, and in the midst of that investigation, because the service member has to be mission ready, maybe on a plane or on a ship headed somewhere, and the other non-active duty member is left to fend for himself or herself with the courts, with the base, and with the kids being in or out of home care. Is there a deployment going on? Is there going to be a deployment anytime in the near future? If so, when? And very importantly, in neglect and abuse cases, probably in every court-affected family's case, where is your family support located? Are they local? Are they all the way across the country? Do you have any close friends in the military that are stationed where you are? Can they be a resource to you for temporary care of the child while your case is being investigated? And importantly, one of the things we don't think about as civilians, is this a permanent assignment that you're on, or is this temporary duty? Are you going to be transferred somewhere else? Do you live on base or off base? Again, as Judge Fleming indicated earlier, and Judge Carr, it matters from a jurisdictional perspective, and also the main workings of any case, but especially a neglect and abuse case. The members themselves, the family that's in your court, may not know whether there's a memorandum of understanding with a military installation, but you may find in a military connected case that other officials from the base are present in your courtroom. A JAG officer or someone from the JAG office from that base, if there's a local base that is your kiddos and families are involved in. There may be other members. The person that is the superior, either non-commissioned officer or commissioned officer for that person who's a military, active duty military member. And very importantly, even if you don't have any tribal nations in your community, it could be an Indian Child Welfare Act case. It's important to ask that question. In fact, it's required by the federal act that we judges are supposed to ask early and often, is there any reason to know whether this child is an Indian child or not? The second page of the child welfare bench card, Sherry, I can advance that, I guess, or you can, I'm not sure. There you go. I'd like to look at the right side of the screen first, considerations, and you can read those for yourself. Very important to ask those questions. I've mentioned already that military personnel have a right to be present. Make sure you identify who those are on the record. and be respectful of who they are. If you're not familiar with military procedures and hierarchy, they are there not because they have nothing better to do, because they're required to be there. If we have family time or visitation orders, it's important to know whether the family resides on base or off base. If they reside on base, your workers may have to do some other things in order to be able to get on base to visit the family, whether it's the family themselves or the family that is the out-of-home placement for the child or children. Does the interstate compact on placement of children apply? That's really critical. I know it's a favorite subject of Judge Fleming, as we've had some of our sessions, and how that may be unjust or necessary, and how do we comply with it because we're required to. And remember that many military connected families, not just the active duty member, have some experience with trauma, trauma of being separated, trauma of seeing, other family members experience the loss of a loved one. The children having trauma because they've experienced the loss of one of their classmates' father or mother due to military connected service. One of the things that we should all be mindful of is that most families in our country have pets. Pets are considered part of the family. When you're thinking about family time plans, are the pets included in that? That pet may be the one source of comfort for the child who is the subject of the neglect and abuse petition. So don't neglect to ask about pets. Quite frankly, if you ask a young person in your court about whether they have a dog or a cat, they will start talking like you've never heard them talk before, because they relate to their pets and their personal connections. Some family members consider their pets more important to them than a sibling or a parent. And again, the importance to ask about the Indian Child Welfare Act. So one of the things that I will finish off with is by asking about the family advocacy programs. Something that we may not be aware of in civilian courts, but they can be and are a tremendous resource, not just to the active duty military member, but to the entire family. As far as services, those services may be readily available to them on base, whereas in some deserts like New Mexico, I don't mean physical deserts, but in terms of services, those services may not be available, particularly if you're in a rural county, but they may be available on your base, on the base. In New Mexico, we have 3 military bases that are active. One of them is in the county that I served in when I was on the bench. But even if you don't have a military base near you, that doesn't mean you don't have a military connected family in your court. It's important to ask. Also be mindful of the timelines that military folks are subjected to, where they may not apply to us. I'm going to stop there, and I believe Judge Fleming is going to talk next.
Yes, Judge Fleming, you're going to come off audio. We're going to have you talk about the family violence and emergency relief bench guard.
Yeah, thank you, Judge Romero. Thank you, Sherry. I want to follow up one thing that Judge Romero said, because it is kind of the passion of mine, and that is the ICPC, the interstate rules that we have to follow when we place children out of state. We do punish our military with the ICPC, because the ICPC, as it's currently written, doesn't allow us to place children outside of the state without getting that report. And as you know, it takes anywhere from 30 to 60 days on a very quick Regulation 7 ICPC, all the way to 6 months to a year. And most of our military do not have family members that live in the state that we're removing the children from. Where they're stationed is generally a state that they're not actually from and they don't have relatives at. The ICPC 2 corrects this issue. There is the framers of the ICPC actually came out with a second version of the ICPC that will go in effect once 35 states have adopted it. Last I looked, only 14 states have adopted it, and it's kind of stalled in the rest of them. So if you have any pull with your legislature, ask them to look at the ICPC too, because our military desperately needs it, because we would be able to place children with family members instead of placing them on foster care and giving them the extra trauma that they have. If you don't have that, the next best thing is, if your state does not have a fictive kin statute, is to get your legislature to pass a fictive kin statute where we can at least place the child with a person who is like a aunt or uncle or grandparent to them, which is usually another service member. That's how Kentucky has, we changed our law about 5 or 6 years ago in Kentucky, and it's been a godsend for us. So I'll get off my little high horse there and my little soapbox, and I'll get back to what I was asked to do. So I'm going to talk a little bit about emergency relief and family violence. My questions that I have are very similar to the ones that Judge Romero had, with a little bit of difference. You know, he asked, who are the parties? Mine is, who is the alleged abuser? You know, is the alleged abuser a service member? Is it a non-service member, meaning usually the spouse? Or is it both parties? And that makes a huge difference when you're talking about, especially civil protective orders. When we're dealing with, we call them in Kentucky domestic violence orders or interpersonal protective orders, but for our sake here, we'll just call them civil protective orders. When you're talking about civil protective orders, they are very, very important to military families, because there are two types of relief that military families can get. One is the civil protective order, where they come to our court and ask for a protective order. The other is a military protective order, where they ask the military to intervene and help them. There's some huge differences between those two, which I'll talk about in a little bit. But as far as if you are a non-service member victim, it's probably very important that they seek relief in the civil aspect as well. Because once that service member leaves base, a lot of times those military protective orders aren't worth the paper they're written on. So if you wonder, when a spouse of a service member comes to your court saying, I need a civil protective order, and you're like, well, you already have this military protective order. That military protective order does not have near the breadth that the civil protective order has. The where are you stationed is very important for jurisdictional issues, not only in the domestic violence realm, but also in the emergency relief realm. You know, they ask, is this a permanent or temporary station? With the military, there are no permanent stations. You know, it's kind of like a permanent custody order. Permanent is just for the time being. But when we talk about permanent or temporary stations, a permanent station is where they are probably going to be at least 2 years, usually somewhere around 4 to 6 years. But that's their permanent station. A temporary station would be more they've gone somewhere for training. They're going to officer candidate school. They may be deployed. They may be going overseas for for example, Korea. If you go over for 1 year, it's a temporary station. If you go over 2 years, then you are actually what we call PCS. It's a permanent change of station. So you'll find with the military, they use a lot of different acronyms. Make sure if you have questions about the acronyms, when you have one of these cases, that you look at our handy dandy reference guide for the different language. A lot of it is very similar to what we deal with on a daily basis. An LES is just a leave and earning statement. That's just a fancy name for your pay stub. But one thing that you do have with the military is basic allowance for housing. And in cases where we're dealing with emergency relief or family violence, that basic allowance for housing is very important, because one, that basic allowance for housing is a situation where if they are living on base, that basic allowance for housing, which is basically just a amount that the military gives based on where you live for how much it's going to cost you to have a house for a month. That is a pass-through expense that just goes to on-base housing. It is non-taxable. You'll find military people will say, "Oh, well, you don't add it to child support because it's non-taxable." No, you add it to child support because it's actually just a benefit that we're giving the military to make them non-taxable. For me, my housing comes out of my normal paycheck, and I'm taxed on it. For them, we give them a benefit that we're giving them their housing separately. But if they separate, and a domestic violence order or a civil protective order can be a separation. If they separate and they live on base, the only money that spouse on base is going to get is that pass through that goes to pay for housing. So unless they have child support, they're not going to get any other money to be able to spend. The military is not going to force them to the service member to support their family in any way other than paying for that rent on housing. So at that point, you may need to either issue maintenance or child support, or both. On the other hand, if they live off base, the military is going to make sure that the spouse, and they have a formula, a lot of times it's 100% of that BAH, but they're going to make sure that service member pays that spouse that BAH, and then they'll have to pay their rent, and they'll probably have a little bit left over for paying for food and utilities and all, because usually what that basic allowance for housing does, it's actually enough to cover both rent and utilities and a little bit of extra spending money living off base. If you do that, then a lot of times they won't come back and ask, the spouse won't come back and ask for maintenance or child support because while they're getting that BAH, because what they're getting from the BAH is more than you'll probably give them in a lot of situations. If you get one of these cases and you get these on a regular basis, there is a 2-volume book. I'm going to give a plug for our favorite Colonel Mark Sullivan. It's called the Divorce Handbook. If you do military law cases a lot, I would get that Military Divorce Handbook. It is 2 volumes, and it has every single issue that you will ever need in a case by case. If you don't get these very often, then our resource guide will probably help answer most of the basic questions that you will have. The final thing I'm going to talk about on this page is the firearms. When soldiers get a civil protective order, the firearms is a real big issue. You have the ability as a judge on a civil protective order to write an exception into your order. And my exception reads something to the effect of the respondent is restrained from having any further access or possession of firearm or firearm ammunition, except in the course of military duties or government issued weapons in the course of law enforcement duties. And the federal law allows us in civil protective orders to allow service members to carry a weapon within their military service, but we have to grant that exception to allow them to do so. Now, if they have a criminal conviction for domestic violence, they are barred from weapons for the rest of their life, firearms for the rest of their life, regardless of that exception. We can't give an exception for the criminal cases, but for the civil protective order, we can give that exception. Do I do it in every case? No, I do it in probably 96% of my cases. If I really feel that the person having a weapon is a huge danger, if they've used a weapon or they used a firearm on their victim, then I'm probably not going to give them that exception. And they'll just have to deal with the military on that. And that can affect their military service and whether or not they're barred to reenlistment, whether or not they're chaptered out of the military, or whether or not they're given some type of sanction by the military. Next slide. Okay. The only thing I'm going to really talk about on this slide is I want to point out we have the differences between a civil protective order and a military protective order. I'm not going to go through each of those, but you just need to know that the civil protective order gives a lot more more protection to the victim of domestic violence. And one thing you do need to know is military protective orders are only against the service member. They're only a restriction of the service member doing something, which means that in cases where the service member is the victim of domestic violence, then they may be placed outside of the household away from their children, and the children are left in the house with the perpetrator of domestic violence. So you may see that a service member may not report domestic violence to their superiors because they're afraid that they're going to be separated and can't protect their children. And then if the other thing is that transitional compensation and support. If the military has a situation where they generally it's where they chapter a person out of the military, they kick them out of the military because of domestic violence. The victim of domestic violence a lot of times is qualified for transitional compensation, which would be a monthly payment. It can go up, I think, to 2 years of monthly payments. So that's something to be aware of when you're doing cases, especially if you're looking at whether or not to do future maintenance or alimony. So at the end, we'll take any other questions, but Sherry, I'll pass it back to you.
Thank you, Judge Fleming, and I'm going to turn this over to Judge Carr to talk about our juvenile justice bench card.
Yes, so the last part of the bench card is about juvenile justice. And as you can see from the bench card that's displayed, it has some of the similar questions that were discussed by Judge Romero and Judge Fleming. But I wanted to first highlight, which is probably the most important bit of information I can give you, is that regarding juvenile justice and military installation, is that juvenile courts do not exist on military bases. This is so important because, as you should be aware and may be aware, the first juvenile court was established in 1899, so over 100 years ago in Cook County, Illinois. And why that's important is that because the creation of the first juvenile court created and marked a significant development in the juvenile justice system, as it marked a shift from treating children or youngsters charged with offenses as adults. That's the major component of the juvenile court system, is that children are different than adults. And it also was a shift to the focus on understanding the developmental needs of children and to focus on rehabilitation and their individualized needs, such as education, mental health, and so forth. So juvenile and family courts are uniquely trained and qualified, not just the judges, but all the professionals who work in juvenile courts to address children who are charged with offenses. And that's what juvenile justice or juvenile delinquency means. It means a child under the age, in most states, 18. It may vary a little bit older than that, but that means a child has been charged with some type of criminal offense. We don't call it criminal because they're children. We call it delinquency. And so military bases very rarely handle delinquency matters, despite having authority to do it. They have the ultimate authority to do it, but they choose not to. I want to believe it's because juvenile courts are best equipped to handle those matters. The law for military bases and federal law gives them the authority to handle those matters. They can have exclusive jurisdiction or concurrent jurisdiction. They often will become involved in a juvenile delinquency matter if it's a very serious violent felony charge or what's called problematic sexual behavior. But anything else tends to be something they're going to leave with the states in the juvenile court system or the family court system. So I've mentioned jurisdiction. As you can see from the bench card, one of the first inquiries, one of the first questions we want to know is this child's parent or legal guardian, currently an active duty service member. Sometimes that's easily learned by the appearance in court because they may come in uniform, or you may see, as Judge Romero mentioned, a JAG officer there or someone in military clothing to let you know there may be a military involvement, or you may have someone from the family advocacy program there, and we'll talk a little bit more about that. You don't need to have both parents that live on the base, at least just one. And you know, a lot of our families are separated or divorced. I'm going to echo Judge Romero's comments about the resources available in the juvenile court system and to those living on the base is the family advocacy program. Is that group involved with this family? Because oftentimes with children who are coming to court, the family advocacy program has already connected with that family and may already be providing services. They are a great resource. They provide support services, intervention, and most importantly for juvenile court judges and probation officers, they help provide that accountability. The military has a strong accountability factor in their enlisted service people, including the children. And so whenever I had someone, whether it was a juvenile delinquency matter or a domestic violence matter or child welfare, and I knew the family advocacy program was involved or just a military involved family, I knew I was going to get great results because there was that extra level of accountability. So you want to find out if the family advocacy program is involved with that family. Other inquiries, and again, like the others, we're not going to list each and every one of them, but one of the issues is this family going to stay at that military base? Are there future deployments? And if that is the case, we always want to know and ensure who's going to be supervising that child. Is that child going to be at the base? Is the child going to be deployed with the parent, or is there a plan for that child to go with another family member, or as Judge Fleming said, a fictive kin, which may not be by blood, but someone that can be trusted with the child. We also have talked about memorandums of understanding. And so that's listed there under number 3. Years ago, when I was chief judge of my court, we worked very closely with the Fort Belvoir military base here in Virginia, and we came up with our memorandum of understanding. And why that is so important is particularly because I've mentioned military bases don't generally handle juvenile delinquency matters, but you may have a child who is on probation, let's say, for a delinquent act, and that child lives on a military installation base. How is that probation officer to monitor that child's compliance? Because a part of probation is meeting with your probation officer, not only the child, but the family. A probation officer doesn't have the authority to just go on a base. A base is federal property. So when you have a memorandum of understanding between the base and your local juvenile court system, that one allows that probation officer to go on that base and meet with that family, to interact, to follow, to make sure that the court's order is being followed, making sure the community is safe with whatever the delinquent act that was committed. So that's an important part of jurisdiction that can be addressed in a memorandum of understanding, which we recommend that all jurisdictions have that, because that gives you the authority to have your probation subject monitored. The other one I wanted to mention was the Interstate Compact for Juveniles, ICJ, which is different than the ICPC, but that involves when, and I'll give you just a quick example, if a child is on a military base and I have found that child to be delinquent, and let's say the child is going to live with father in Nebraska, then I have to have my probation office, we have to send a packet to allow Nebraska to exercise supervision over that child in Nebraska. And so that may happen with a child whose family is at an installation base. So it's when a child is moving between states and that child is under probation supervision. So that comes up in non-military cases as well as those involving military cases. And so one of the things we want to make sure that everyone understands is that the ICJ applies if the family is involved in the military. And the receiving state, so in this case of my example would be Nebraska, they must accept that child as long as one of the parents lives in that sending state. So Sherry, if you could advance to the next slide. The last thing I wanted to mention was I mentioned the uniqueness of the juvenile court jurisdiction, and that has to do with the way that we are trained and educated through our work through organizations like the National Council of Juvenile Family Court Judges to address the developmental needs of children, connecting those children who are involved in delinquency matters with support services, interventions, making sure their educational needs are met, addressing what we now know is almost a mental health epidemic with a lot of our children, including trauma and substance use. And so between the juvenile court and the family advocacy program, the way that we can connect those services to provide those services to that child and his or her family so that they can avoid further court involvement is the importance of coming together with your local military base through that memorandum of understanding so we can keep our communities safe. The only exceptions that are listed there, I mentioned, are it talks about the serious felony offenses, and then the other one for jurisdiction, which is addressed also through family advocacy, is the impact of post-traumatic stress disorder, which, as we should all know, is very dominant with military families. And so that can also impact our children. So that's another resource provided through the family advocacy programs. So with that, I will turn it back over to Sherry.
Great. Thank you, Judge Carr. And thank you to all three judges for reviewing the bench cards with us. So that's part of the package. You just saw what the bench cards actually look like. And then again, the package at the end also has the list of additional resources and the terminology list as well. But to just sort of help everyone understand a little bit more about how to use the bench cards and what some of the additional resources are, our staff team came up with some questions for our panel of judges, and we'll get started with the first question, open to anyone from our panel who would like to respond. Who is the target audience for the bench cards? I do remember we first started talking about the bench cards with our military committee. We had some questions about who exactly are we targeting? Is it judges who have a lot of military connected families? Is it those who do not and maybe do not see these families every day? Who do you think the bench cards are targeting? Judge Fleming.
I think what we ultimately came down to, and I think what the final product shows, is anyone can use the bench cards, but I believe their target audience is probably more for the people who don't have military cases almost every day. You know, people like myself and Judge Romero and Judge Carr, who had a lot of military cases or military connected families, as we like to call them. A lot of these are the basic questions that we just ask in our normal everyday without even thinking of them. Because we deal with so many cases from the military. But if you're a judge that doesn't get 200 military cases a year or more like we do, you need to really think about some of these particular topics. And I think these bench cards are a good refresher for the ones who don't do it every day. It has a lot of the basic questions that you need to know, and a lot of the part about bench cards is to make you and the parties think about different issues and think about, oh, we need to address this, and oh, we need to address this. And I think these bench cards do a good job of that. And then when you get down into the weeds, you can do other research for some of the more specific topics, including going to the resource guide that we have, or going to some of the white papers that are available.
I would like to also add that, while one might think initially that the target audience is the judiciary, the bench officers, I would suggest that as part of what the National Council teaches judges is we need to exercise our judicial leadership and do some training for our court partners, whether they're probation officers, child welfare workers, attorneys who work in child welfare and in juvenile justice, so that we share the wealth of information so that they know where to look to as well. And that would make everybody's job easier, and it would benefit the families involved, which is quite frankly why we're all here, to serve the families and children that appear in our courts, and to promote better outcomes for those families.
So I'll just add to that real quickly. Sherry mentioned we have some terminology in the bench card. I think that's eye-opening in it itself, because sometimes when you're dealing with military connected families, they're kind of speaking a different language that you don't understand. And just having that terminology can really help a judicial officer or a probation officer or anyone to have a better understanding of the family.
And each branch of the military has their own language. I think Judge Fleming used basic allowance for housing, BAH, and the Navy it's BAQ, basic allowance for quarters. The Navy calls where they're stationed the base. The Army calls it their post. So there are a lot of different uses of the English language that mean different things to different branches of the military. So that reference and that resource that Judge Carr mentioned can be very helpful as we weave through these cases if we don't get a lot of them annually, and help us understand what's going on.
And our next question is, my court's not located near a military installation where I still need to use the bench cards. You've touched on it a little bit. Is there anything more you'd like to say?
The only thing I would add to it is I kind of think of this as kind of like the Indian Child Welfare Act. I don't live in Oklahoma where there are hundreds of tribes around there. We don't have a single recognized tribe in Kentucky. So I'll end up getting 3 or 4 ICWA cases a year. And the first thing I do is I pull out my bench cards. So I think that if you're not located near a military installation, you will probably use the bench cards probably more than a person like me who is located next to them.
And I think a prerequisite to pulling out the bench card is to know the answer to the question: is this a military connected family? And as Judge Fleming certainly made very clear, military connected families are everywhere, not just where there is a base near your court.
Thank you. How do I know if I have a military connected case in front of me?
Well, I kind of alluded to that a little bit earlier. One of the big indicators for me is when they come in as depicted here on the pictures. They often come in uniform. You know, if it's someone who's enlisted, sometimes they come in uniform. Sometimes it comes through with the information that you're gaining. Sometimes it'll be on the paperwork, the petition. We were talking about the old APO address, which was the military PO box that all the enlisted members had. But oftentimes it's apparent and sometimes it isn't, but you can certainly ask.
I think back to my point earlier about judicial leadership and training those who work in your system. They should be the ones that are asking before that case ever comes before you. But if they don't know to ask during their initial contact with, whether it's a young person alleged to have committed a delinquent act, or you have a domestic violence case, or a child welfare case, they should be already on top of that question, the answer to that question, whether these folks have a military connection. But they're not going to know that if we don't train them and train ourselves.
And one thing that we always get, one of the first motions that I get in most cases, regardless of the type of cases, is a child support motion. And in the child support motion, the first thing they're going to do is attach their pay stub, which if you see leave and earning statement, you know that they are military if you see leave and earning statement. And by the way, that leave and earning statement has a ton of information on it besides just their pay. It has when they started in the military, when they're going to potentially get out of the military. And one of the big ones is, and it's right about 90% of the time, down at the bottom in all these little boxes, there's one that says state for state taxes, and it will have a state there. And generally, that is their home domicile. Not always, but generally it is. So that leave and earning statement, besides just being a pay stub, has a ton of valuable information if you learn how to read it.
One of the
So,
things that we've failed to mention is a very important federal requirement, the Soldiers and Sailors Civil Relief Act. That's another thing you need to delve into, that if you don't know whether this family is military connected, you may be proceeding contrary to federal law as set out in the Soldiers and Sailors Civil Relief Act.
one other area that it's come up as more and more courts are creating or specialty dockets. For example, my court in Fairfax, Virginia has a veterans treatment docket. And so that's in the service members' best interest, we could say, to let us know they are military connected, because it's sort of a diversion program for domestic violence or criminal cases or any type of case. So it's really important that we start training judges and staff to identify military connected families for the various benefits that can be provided to them, and then help them understand the uniqueness of a military connected family.
What makes cases with military connected family members different from other cases? I know you've mentioned that throughout your presentations. What else would you like to add?
Well, I'll start with juvenile justice. I mentioned the uniqueness of juvenile court, what we focus on, and then how we like to rely on the family advocacy program to help with those support services. So that's sort of a double layer of service that a family can receive in terms of helping that child reach the rehabilitation level. And I also mentioned the extra accountability. I mean, as judges, we want our orders complied with, because we believe those will help people make better decisions and stay out of the criminal justice system. So the more layers of compliance and accountability that we have, the better chance we have of helping that family improve outcomes. And so a military connected family, through family advocacy, through the chain of command, allows us to do that. And that's one of the areas that makes military connected families different from other cases.
I want to correct myself when I made mention to the federal act of Service Members Civil Relief Act. I'm an old guy, so I still remember it under its old name. I think one of the things that we talked about were memoranda of understanding, memoranda of agreement, whatever they may be. Those not only help understand how we're going to proceed, but it keeps the military authorities in tune with what's maybe going on in the civilian area. This happened very recently in a case where the military folks did not know that the service-connected member had a DWI case. Had they known, had they shared information through a memorandum of agreement or understanding, they may have had different eyes on this person who was on base with his own personal gun and shot a number of fellow soldiers.
I'm going to talk about one of the frustrating points of dealing with these cases, and this is something that you need to also be aware of. A lot of times, the military do a really good job of taking care of their own and helping their own. They have a ton of services on base that civilians do not have, especially through FAP. But one of the problems is a lot of times they are a closed community, and they don't like a lot of outside influences. So sometimes when you see these child welfare cases that come in your court that come off of base, you may see that they've tried almost every service on base before they got the local child protective services involved, and before they got the court involved. And by the time that you get the case, there's not much else that you can do as a court other than look for placement under the ICPC or look at termination of parental rights and adoption, because they've done almost all the services that you could have. There's a lot of times I would like the military to bring me cases sooner than to work with them on the base without court involvement, because I think we would have better outcomes if we worked as a team on those issues.
I think Judge Fleming's point is well taken, and one of the things that makes military cases, or can make them different from our regular cases, is time is of the essence. Deployment may be just around the corner. The service member may already be deployed, And that impacts on how quickly we can take other action to meet the needs of the family. So time is always very critical. The other thing is the military tends to put their primary emphasis on, is that service member mission ready? To take them and have them involved in civilian court, is that going to affect their readiness to do what they've been trained to do in the welfare of our country?
Yeah, I'm gonna agree with that as well. I've seen it, unfortunately, a lot in domestic violence cases where the alleged victim has reported that they felt like the military just closed quarters, didn't want to address it, and they felt they didn't have any recourse because family advocacy got involved, but are they really getting involved? So it's something we have to make sure we're attuned to.
This next question is very similar to the previous one. If there's anything else you want to add, but I love this photo because it was taken during Purple Up Day, which is a day where we honor children who are connected to military families. There are schools on military installations. That's another reason why you might need agreements between courts and military installations, is access to youth when they're in school for monitoring. And so this is a school that's honoring their kids who serve with the military.
The only thing I would add to what we've already said is on your divorce and custody dockets, when you enter a final order in the case, think about the future, because in most of these cases, one of the parties is going to either be transferred at some point, or one of the parties is going to go back home while the non-service member is going to go back home. So when you're doing your custody and visitation or time sharing, make sure you write in the contingencies of a long distance visitation plan. It will save you a lot of time in the future of relitigating things you've already litigated.
Why are bench cards necessary for cases with military families?
Well, I think as all three of us have touched on the three different bench cards, there are questions there that need answers. And the failure to get those answers directly impact the decisions we make. And we could, in the best, with the best of intentions, make decisions and enter orders that work contrary to the welfare of not only the children involved, but the families themselves, and even that military member's future in the military, maybe being asked to leave the military, or they're not even asked, they leave, and that affects the financial and emotional welfare of this family from that day forward. So we need to know what questions to ask and how those answers impact the future decisions and orders we might be making.
This is a big question. What are the jurisdictional issues to be aware of regarding military connected families living on and living off a military installation?
Understanding the BAH rules is very important when you're talking about living on or living off base, because the application of them is different. Every part of the military requires their soldier to support their family, and they all have their own regulations for that. The Army regulation is Army Regulation 608-99. It's about 40 pages, and it has all these different scenarios in it of how much they have to pay depending on different scenarios. So that is one of the issues. And then the other one is the one that I touched at the very beginning about being at Fort Campbell, where half of it's in Kentucky and half of it's in Tennessee. When you're living off base, it's really easy to determine what jurisdiction you live in. When you live on base, it's not as easy. You may have to pull out other resources, such as the fake maps to determine where the state line might be, or even the memorandum of understanding that will say this court handles this type of case.
I think one of the things we also have not really touched on is the issue of children who are in the child welfare system, but may also have a juvenile justice case. And the duly adjudicated kid, and if it's a serious offense that the military is going to exercise their jurisdiction in, how do you deal with communicating with the military authorities when they are going to prosecute that child as an adult in federal court, and you meanwhile have that child and his or her family on your docket in a child welfare case or in a divorce case? Things that we hope never happen, but if they do, how are we going to deal with that?
And then our last question is, what other information and resources from NCJFCJ is available for judges to help them understand the issues, the contexts that are unique to military connected families that come before the courts?
Well, I think we've addressed most of them because we've talked about the resource guide and we've talked about some of the white notes and all. One thing, though, that I would suggest is also the ability of having a staff member from NCJFCJ help you coordinate with your local office, especially if you are stationed near, if your office and your court is near a base. Judicial leadership is extremely important in these cases. And I have the fortunate of, we have a group that meets once a quarter that is made up of law enforcement, social services, the court system, about every service that you can imagine, mental health on the civilian side, and then their counterparts on the military side. And that is with Christian County, Montgomery County, Tennessee, which is the other side of the base, and the on base as well. And we kind of have a flowing of information of having this quarterly meeting to try to figure out where are our lapses, what more information do we need to provide back and forth with each other. What happens in this particular scenario? Judge Romero mentioned the scenario that happened just a few weeks ago on the military base where a person shot soldiers on base. We have a plan to be able to address things like that, of things that happen on base, of securing the off base stuff. So that all started with judicial leadership of the judges from both counties coming together and bringing all the parties together to be able to have these quarterly discussions. So I would urge getting NCJFCJ available to help you be able to figure out who needs to be at the table to coordinate those type of things.
Thank you, Judge. We're going to move on to the open Q&A portion. Oops, let me go back. Before we do that, if you're interested in other types of bench card resources, this is the QR code that goes to our bench card resource center. This bench card package is in there, as well as many others on the topics listed. And then again, you can go to our National Resource Center of Military Connected Families in the Courts. This is what the homepage looks like. These are the different tabs for the resources. The QR code will take you directly there. If you have questions after the webinar, or you want to request the hard copies, please feel free to email me and let me know your mailing address and how many copies you would like, and we can send those to you. But we do have a question for our panel, and that is from April. Feel free to come off mute, April, to ask your question, please.
Thank you. Good afternoon. I appreciate all the panelists for the information they've shared so far. So thank you. I know there was a mention about pet safety considerations. Can anyone from the panel elaborate on what are the options or possible responses the court could have to ensure pet safety or like visits and things like that? What kind of things might we expect from a court regarding pet safety?
I'll try to tackle that in an informative sort of way. One of the things that's going on nationally, not in every state or in every community, but there are pet-friendly shelters for those who are victims of family violence, and they accommodate dogs, cats. Some of them even have facilities for larger animals like horses and cows and that kind of stuff. So it's very important to be aware of what's available in your committee. What Judge Fleming was talking about was a fancy name for all of that effort by the judges in Judge Fleming's neck of the woods is coordinated community response. There are a lot of services in our communities that we don't know about if we don't get everybody together and address these issues. One of the other programs that I'd like to, shamelessly make reference to is the National Council's Justice. It's an institute that we have every year on what every judge needs to know about interpersonal violence and animal cruelty, which would answer a lot of these questions. But that's a beginning. Martha Blomquist, who is listening in on what we're talking about today, is a great resource with the council that may be able to provide you, and not maybe, can and will joyfully provide you more information on that subject.
So I would just add, April, just to give you another example, in Virginia and probably in many states, when I'm hearing domestic violence requests for orders of protection, I have the authority to order the victim to have custody, if you will, possession of an animal. That's one of the ways many legislators across the country are addressing the link between domestic violence and pets. So I've ordered cats, dogs, snakes. They make that a part of their petition for a protective order, and I can order that someone takes possession of that animal pending either the next full hearing or for a more permanent protective order. So the issue of pets and safety and DV and other things are really now more and more involved in our jurisdiction.
And even if your state does not allow or does not have a specific provision to protect pets, generally there is a catch-all provision in your domestic violence statute that says that you can do anything to help prevent domestic violence in the future. So I take that to mean, because Kentucky just got the pet one about 2 years ago, but I was already ordering pets before that, way before that. And one of my reasons for that is, like Judge Romero said, people treat their pets kind of like their child, if not sometimes more important than their child. That if I go ahead and I allocate that pet, then I've taken one less thing for them to fight over. So that's generally my argument. Plus, I've taken it out of the victim's realm of having to say, no, you can't have it, and put themselves in danger. She can now blame the judge. Well, the judge did that. I didn't have any say. The judge did that. So I'm now taking the blame, not the victim.
We are at the end of our webinar time. Please feel free to email us if you want the printed copies of the bench card. If you need a documentation for any continuing education, legal education, or units that you're going to need for your profession, any questions that you have. But I really want to have everyone just thank our panel of judges for presenting this information to us and getting these bench cards out to the public and having them disseminated. And thank you everyone for joining today. We certainly hope that you found the bench cards useful and as a tool that you will use going forward. Thank you and have a good afternoon.
Thank you.
Thank you.
Thank you.
Thank you.